First of all, thanks for being here this Monday night. There's a lot going on in Austin, Texas right now. I have two additional meetings that I guess. I'm going to say a few things that most folks require to know about. If you don't know, of course, in January this year, a very historical case was presented. Folks who don't know, it was Shelby County, Alabama versus Holder. But prior to that, Voter Rights Act was enacted to ensure that no federal, state, local government in any way impeded people's right to vote, register to vote. Of course, what has happened this year in Texas and the whole country, primarily Texas, for this purpose, it's changed everything. It's a whole different universe now. The fact that Section 5 was gutted through Section 4 changes all of our activities for the most part. Always around folks when I'm talking to them that in spite of Section 5, Section 2 is still into effect. And Section 2 is permanent. So any kind of discrimination is prohibited under Section 2. That's important because a lot of folks don't know that. When I'll talk to them, they think that the whole entire act was gutted now. You can still fight discrimination in various kinds of ways. I think most folks here know about what happened with Holder versus Shelby County. I'm going to talk about things that we're doing right now. I'm going to go right to the source to try to at least inform people. And that's part of our problem, is that a lot of people right now are not just not informed. They're not organized, they're not mobilized. And I can tell you that we worked hard to let folks know about tonight's meeting. There's so many distractions, and I think therein lies our challenge. How do we get people to tune into this very important issue? We're working very close with Travis County, Texas, as Bruce Alfred, and also Ms. David Waters, Travis County Clerk. There are a few things I want to mention that are very important. In yesterday's paper, you might have seen that the DPS is going to be open from now until November 6th, from 10 a.m. to 2 p.m. all across the state. And in each city, they're going to tell you different locations that folks go to who do voter ID. This is going to be what it looks like. So we've been sending folks to the DPS website to see where they live and also what the hours are on these Saturdays. These hours are specific for voter certificates, so that's important that people know that wherever they are in different regions, there will be accessibility to get these certificates. Even that's been a challenge thus far, is getting folks to respond to our emails about the hours that are available and how important this is. And I want to say off the top that in Travis County, we've been very fortunate to have David Wall here, Dana, who has been very open to us and sort of catered to everyone in terms of information, making sure folks are informed. She's on numerous shows in our community, churches, letting people know that no need to panic. There will be a way to get certificates. They're free for the most part. But she said the same thing, that she's having difficulty getting folks to respond thus far. So we're going to have to examine ways to get people more involved with this process. The main thing I tell folks is that these certificates for ID are going to be free. And they don't quite understand that. A lot of folks don't know that they're going to be free. Well, they should people understand that so that they're not discouraged by incurring any kind of cost. And that happens a lot in my conversation. I think there's some kind of cost attached to it. The other thing is name on the photo ID must match the name on the voter registration list. That's not going to be a big deal, but there's something to be just concerned about. That if you get the card, make sure the names are printed exactly alike. There have been a few cases where people have been sort of approached about that in the past. So we tell people, make sure your name is the same on both your ID and your certificate. Of course, the other thing is we always anticipate folks who don't have ID, some folks just not going to comply. So I always let folks know that there's a thing called a provisional ballot. If you don't have the ID with you, you do have another day. So you can always use that as a last resort. Yeah, I think you have like 6 days to come back, 6 calendar days to come back and complete the process. It's also important to know that there are permanent exemptions. For example, a voter with disability without an approved form of ID may apply with the county voter registrar's office. But permanent exemption, that's also important for folks who have disabilities to know that you can also apply and not be frightened by this whole process as well. I've had a few calls about that as well. Even temporary exemptions. For example, there are certain religions who don't take photos. They can also appeal the process as well. And I thought that was very interesting, that they can also cast a provisional ballot if you have a certain belief where you don't want to take photos. You can cast a provisional ballot as well. That's important. Voting by mail, you can vote by mail if you're a registered voter. And if you have to be 65 years old or older. Those are some of the basic things that the clerk's office is putting out to folks. I've seen them at various churches already. And I've visited a lot of churches in East Austin, and I can tell you I've seen 30 or 40 where these things are all over the place. So they are talking about what people need to have in order to vote. I just think the biggest challenge I've heard about thus far is getting people mobilized so they know that right now the law in Texas is voter ID. As of this point in time, it is the law.
Well, I want to say thanks to y'all also for showing up, and to Nelson for co-sponsoring this. And there are two parts in this fight to vote. One is what Nelson was talking about, getting people out to register to vote, or get the ID that's needed to vote. I mean, that's very important. And the other part is that we're trying to do here in Texas is organize a series of meetings around the state with people that will help us monitor school districts and help us monitor local elections. As Natasha will talk about, there's a challenge to the larger laws right now, to the Texas voter ID, but it's very important for us to be on top of the stuff that's happening. Because like Nelson said, we didn't lose everything, but what we did lose is the burden of proof. So before, everybody had to send in the changes, and DOJ had to approve them. So that made it easy for us. But now that that mechanism is out, for us to file the suits, we have to find out where the stuff is going on. We know, for example, in Beaumont, they're trying to get rid of the single member school board, which is all African American right now. Pasadena is trying to change the city council to go from 7 single member districts to 5 single member districts and 2 at large, which helps, disenfranchise stuff. We have a problem with Del Valle, postponing the elections for a year. So we know just that stuff is going on, so we're trying to organize not only the component of getting people to get the ID, that's very important, but also to monitor these jurisdictions, so we have lawyers lined up that will file these cases. And but we need to ask people to help watch. And after Natasha talks, we'll come back and talk a little bit about that and see maybe how you can volunteer or get some friends to volunteer to do that. It's really strange. We spent most of our life trying to make it easier to vote. We changed all the laws so it got easier and easier and easier to vote. And now we're just totally opposite, where the people in power are making it more difficult. Natasha has actually confessed that she is a Yankee. Definitely, and see, she has no. We'll send her over to the Texas legislature and Massachusetts originally, and then ended up at law school in New York, and continued to work in New York with the NAACP Legal Defense Education Fund. I said that right.
That's right.
And part of this organizing we've been doing with lawyers and so on. Natasha's a friend of one of the lawyers, and so she's already been to Texas once, and we're very happy to welcome her back to Austin. We appreciate you bringing the rain with you. That's very nice. And I'll turn it over to you.
Okay, well, thank you all. I am a voting rights attorney, as Jim said, at the NAACP Legal Defense Fund. We are located in New York, but the majority of our cases and all of our voting rights cases, basically, are in the Deep South in places that were formerly covered by Section 5 of the Voting Rights Act. So just to give a brief primer, the Voting Rights Act, as many of you, or maybe all of you probably know, was passed in 1965. It was passed against not only the backdrop of the entire civil rights movement, but specifically the backdrop of states, mostly at that time states in the Deep South, really being exceedingly defiant when it came to enfranchising people of color and African Americans particularly. Basically, the situation before the Voting Rights Act, or immediately prior to it, was that states would set up some kind of scheme, or I shouldn't say just states, it could be any kind of jurisdiction, a state, a town, a school district, any kind of voting jurisdiction would set up a scheme, or a number of ways to do it, that would disfranchise people of color. And as soon as litigation was brought, generally it would need to be in a federal court to challenge whatever that scheme was. No sooner had the case been brought than then the jurisdiction would change to a different scheme. So basically you could file as many lawsuits as you wanted, but you could never catch up to the malfeasance of the jurisdiction. And for that reason, when Congress considered the Voting Rights Act, when it was a bill before it was actually a law, they considered what became Section 5 of the Voting Rights Act. Section 5 basically served as a checkpoint for discrimination in voting. It required certain states and jurisdictions with the worst histories of persistent racial discrimination in voting, as Jim said, to submit to the Department of Justice or to a federal court in DC any proposed voting change that that state or jurisdiction wanted to make before that change could be enacted, and to show either the DOJ or the federal court, the state or jurisdiction could elect which, that the change that they wanted to make would not retrogress against voters of color. And basically what that means is would not put voters of color in a worse position than they were in at the time. So that was the standard, as Jim said. The burden was on the state, which is very important and very different from litigation as we all think of it, where the burden is kind of on the person or the group who's saying that the bad thing occurred. And this was a way to catch up with what states were doing with the pattern of making new changes every time a past discriminatory act was in litigation. So Section 5 was the mechanism by which those places were required to submit changes to the DOJ or a court. Section 4B is the section of the Voting Rights Act that said which places in the country were required to do that, because it was never all 50 states. It was only those places with the most egregious histories and places with patterns of passing these laws as soon as one was challenged. So Texas became covered, I believe, in 1970. So not right away in 1965. And then it became covered again in 1975 when Congress amended the Voting Rights Act not only to include racial discrimination, but language discrimination as well. As you all know, perhaps much better than I do, Texas is a state with one of the really worst histories of racial discrimination in voting. This state is unremitting throughout history in its efforts to suppress the political power of communities of color. It is the only state that has had, after every redistricting cycle since it became covered, at least one of its statewide redistricting plans struck down or blocked by the DOJ before it could go into effect. And as I'm sure you all know, in this most recent redistricting cycle, Texas can boast the accolade of having been found to have intentionally discriminated against voters of color in the state house, and I believe also the state senate plans, which were rejected and they're now still in litigation. Or I think, did they just recently adopt one in the Section 2 court?
Not yet.
The redistrict, okay, so that's
They're
still
still
going
hearing it.
on. It's very complicated and most unfortunate. As you also all probably know, Senate Bill 14 is Texas's new voter ID law, which you spoke of not long ago. It's very, very strict, and it was passed legislatively in 2011 before we lost Section 5 of the Voting Rights Act. And I'll explain in a minute how exactly it came that we don't actually have its protection anymore. But that voter ID law, SB 14, was passed by the state legislature in 2011, I believe. And the state then, under Section 5, was required to get permission from the DOJ before it could actually implement it. The state did that in late 2012, or late 2011, rather. And by early 2012, the DOJ had looked at the state data and the submission that the state gave to prove that it wasn't going to be a retrogressive law. And the DOJ actually said, no, we're looking at your statistics, we're looking at what we know on the ground, and this actually is going to make it much more difficult for people of color to vote, so we're going to deny pre-clearance. Basically, that means deny permission to enact the voter ID law. Texas then filed a lawsuit, which it's entitled to do, in a federal court before 3 judges in Washington, D.C., to similarly ask for the same kind of permission. Under the Voting Rights Act, the states can get that permission either from the Department of Justice or from the court. So it tried the second time, as was its right, and we had a full trial on the merits in July 2012. And in that case, it was Texas suing the Department of Justice. My organization intervened in that case, and we represented a group in Houston called the Texas League of Young Voters, as well as a group of students from Texas Southern University and Prairie View University, which are both near Houston. I'm sure you all probably know that. So after a 5-day trial before 3 judges, which we thought went pretty well, we waited about a month for a decision. And in August of 2012, we got a decision from that 3-judge panel. And frankly, it was excellently written and a scathing critique of this awful law. The judges called it the most stringent voter ID law in the country. They said that they didn't need to reach the question of whether there was discriminatory intent because the discriminatory effect was so clear. But a statement like that kind of left open the possibility that had they been required to, they would have found discriminatory intent. There was testimony provided from voters, from voting groups who assist communities of color in getting registered and in actually getting to the polls on Election Day. There was some really good testimony provided by some of your local state electeds, especially I think Senator Ellis provided really good testimony. Representative Anchia, Senator Davis, they spoke really convincingly and thoroughly about all the ways that they tried to make this voter ID law not the awful law that it was, all the different ways they tried to make it better, the different amendments that they put before the state legislature. For example, allowing student IDs to count, at least those that are provided and issued by Texas state universities. That was summarily defeated. I remember Senator Davis testified that she tried to get an exception to the ID requirements so that indigent people, people who really can show that they don't have enough money to pay for any kind of ID, would have those fees waived. That was also rejected. And as you said, although there is a free ID technically that's provided by the law, and it's very important for voters to attempt to take advantage of it, the reality is there are a number of underlying documents that you need to show in order to get that ID, and some of them can be quite costly. Things like birth certificates, which I think in Texas are $22, which is not nothing. But if you happen not to have been born here, of course it would be more to actually seek to get it from wherever you're from. You also need a social security card or something like that. I don't know about any of you. I don't have one. I know I have a social security number. I have no idea where the card is. I have no idea where. I guess my birth certificate's in Massachusetts somewhere. But these are things that are not actually easy to get your hands on, especially if you have a life that requires you to take care of children and you can't afford to get babysitters, or where you really need to work every hour that you're scheduled to work, or for 100 other reasons that we could all go through or think of. There's a lot of reasons why the free ID isn't actually free. It's just said to be free if you're the right kind of person with all of your documents perfectly organized and in the home where you live, which is not the case for many people. So the Shelby County case was separately, moving away from Texas, a case that, as Mr. Nelson discussed, was brought by a small county in Alabama. So meanwhile, while this voter ID stuff is happening, this other case is also happening. Shelby County is a county, I guess it's about 35 minutes south of Birmingham in Alabama. It's a small place. It's pretty sleepy, I think, from the couple of times I've been there. They lodged an attack against Section 5 of the Voting Rights Act, though. Shelby County was, of course, in Alabama, a fully covered state, as I'm sure you can all imagine, under the Voting Rights Act, and in fact a state with one of the worst histories. Certainly it rivals Texas's sordid history of voting discrimination. Shelby County brought a constitutional claim against Section 5 of the Voting Rights Act, suing the Department of Justice in federal court, saying, in essence, that Section 5 should be declared unconstitutional. The pith of their argument is that it treats states differently, and there may have been a time when that was appropriate, in the 60s, maybe even in the 70s, but that surely we can all agree that that time has passed. In that case, but we mounted a defense, and basically the pith of our argument was Congress, when it reenacted or reauthorized Section 5 in 2006, which was the most recent reauthorization of Section 5, looked at 15,000 pages of evidence, heard from over 91 people who submitted testimony both on paper and in person, and really took months and months to consider, do we still need Section 5 and are we still getting the right places? And Congress, as it's empowered to under the 15th Amendment, made a judgment based on the evidence before it. And in its judgment, we still did need Section 5, and we still needed Section 5 to be reaching the same places that it had been for the previous 4 decades. So the Supreme Court heard oral arguments in February of this case. They heard from the other side, and we presented our arguments, they on behalf of Shelby County, and the DOJ on behalf of essentially the statute, defending it and saying we still need it, and we on behalf of our clients, really. We said, certainly Shelby County, of all places in this country, is really not the right place to bring this kind of attack against Section 5 of the Voting Rights Act, because our clients' lived experiences will show you that racial discrimination in voting is very much alive. For example, our client, I told you about him, the one black elected official in the county, had his district drop from being 51% African American to 7% through some really fishy annexations, where annexations were presented to the county, some white neighborhoods, some black neighborhoods, and somehow all the white neighborhoods got annexed to his district, and somehow very few or none of the black neighborhoods got annexed to much of anywhere, and that completely diluted his district. So we did our best, but in June we found out that we had lost. We didn't lose everything, though. It's important, I mentioned earlier that there's Section 4B, which doesn't get a lot of airtime, but that's the part of the Voting Rights Act that says which places have to comply with Section 5. The court declared that Section 4B was unconstitutional. It didn't really deal with the record, as Justice Ginsburg's dissent points out aptly. They didn't really talk about why that evidence wasn't enough, why the 15,000 pages weren't enough. They also didn't really talk about why Congress didn't have the power to make a judgment on those 15,000 pages. Instead, they just kind of said, there's always sort of going to be racism, but it's really not that bad anymore. And certainly it's not worse in some places than others. I'm sure that we can all agree in this room that our lived realities show us that that's absolutely incorrect. And in fact, I can tell you that the record showed that that wasn't correct. That's why Congress reauthorized it. A bipartisan Congress almost unanimously did. So we're now left in the wake of the Shelby County decision, where we've lost the prophylactic effect of Section 5, even though it still exists. We have Section 2 left. As you said, it's a permanent part of the Voting Rights Act. It's a section that operates much like any other laws, any other civil rights laws that you would think of, which means you can bring a lawsuit in federal court after the bad thing has happened. But we've lost the benefit of time. We've lost the ability to know the changes before they actually have been implemented. And that is what the network that you're establishing seeks to work against, is to recreate essentially a new Section 4B through the people, where we're telling each other about the changes that we're seeing that might be fishy and trying to do something about it as soon as possible. We've also, from a legal standpoint, lost the advantage of having the other side have to show the burden. So just like most lawsuits, most kinds of lawsuits in Section 2 lawsuits, we're the ones who are going to have to be showing what the bad thing is, and we're the ones who are going to have to be proving that it's discriminatory. Whereas when we had Section 5, it was the state who had to prove that it wasn't discriminatory. And that in a lawsuit is a really big difference, even though when you say it aloud, it kind of sounds just like you're flipping the words. But I know all the lawyers and law students here know that the burden shifting is a pretty big deal. Another thing is that Section 2 litigation is very, very complicated. There's a heightened standard of things you need to prove that has been established through case law. There are these jingles factors, they're called. They come from a case called Jingles, where you have to show 3 things up front in any kind of Section 2 redistricting case. Many of those, or at least two of those 3 things, require you to retain an expert. The best practice is pretty much that you should retain the expert before you actually file a Section 2 lawsuit, because you're going to have to prove those things on your complaint. And that makes it also very difficult to file a Section 2 lawsuit, because it's a specialized kind of litigation, and they're very expensive to bring because experts are very expensive. So we're left with that now. We're also left with the possibility of someday, hopefully in the not too distant future, getting a new Section 4B. Everyone thinks it's impossible, and I share the cynicism to a degree, but it is important to note that every reauthorization of Section 5 of the Voting Rights Act occurred under a Republican president. So it can be done, but it won't be easy and it won't be quick. But between now and the time that happens, I think the most important thing, as Jim said, is to create a new 4B among the people, basically, to stay vigilant about voting changes that you see around you or in your communities or communities where your clients live, and to get in touch with civil rights lawyers, voting rights lawyers, as soon as you can when you see something that could be going down, that you want to try to stem right from the jump. The advantage of time isn't one that we have now in the way that we used to, but if our networks remain mobilized, then we can get some of that back. And until we have a new actual Section 4B, I think it's important to rely on one another to be the people's 4B. So that's all I had.
Maybe I misunderstood what really happened. In August of 2012, the federal court ruled that the Texas voter ID violates the Voting Rights Act.
Right. So,
given that, how did it come back to life once Section 5 got, it has been ruled that it violates the Voting Rights Act. So forget sections. Why isn't it dead?
That's a really good question. So basically, the reason that the voter ID law is back again in Texas is that essentially it ruled that it violated Section 5, but because Section 4B was later found to be unconstitutional, in essence it was found to be a violative law of a state that wasn't actually supposed to be covered. It's kind of one could think of it as a technicality.
But if I get convicted for DWI a year ago and all of a sudden this year DWI is legal, or there is no DWI, then they're not gonna reverse my conviction. It's like, that was previous law, it was established, and it's like, so the law changes, you can take everything that was settled under the change law.
I mean, it's a frustrating thing about the law. I understand, but basically anything that was denied preclearance under the 2006 reauthorization, which is the most recent one, if it remains on a state or a jurisdiction's books, which many states and jurisdictions, they kept the laws on the books, they were just not enforceable, then they immediately become enforceable law again. It's basically like it was on the Texas paper. This federal court decision didn't change that it was Texas law. It just changed whether Texas could enforce it under federal law. So we do now, I failed to mention, have a Section 2 case against the voter ID law. It's in Corpus Christi, and in that case, we represent, again, the same client, the Texas League of Young Voters, which is a group in Houston. And now we represent in it also one student from Prairie View, a historically Black university in Waller County. So there's hope yet, but that'll take time because Section 2 cases take a
Didn't
while.
Eric Holder announce that the Justice Department was going to?
Yes,
But
yes. It's the same case, yes. So
So it won't take effect for this election in November, but perhaps.
it will, unfortunately. It is the law, voter ID.
Voter ID, but the lawsuit won't.
Lawsuit,
Won't take effect by then.
right. There's no preliminary injunction. So voter ID, as a practical reality, is back on until we eventually win that case. And another thing that I didn't mention is, I don't know if you all have heard of Section 3C. That's a different section of the Voting Rights Act that has become increasingly important after the Shelby County loss. That enables litigants to try to bring a state or a jurisdiction back under preclearance. And it's been used very, very infrequently. The only two states that had in their entirety been brought, it's called bailed in, under Section 5 were Arkansas sometime in the 90s, like when Bill Clinton was governor there, so maybe even the late 80s, I don't know, and New Mexico in the 70s. And so as a part of the voter ID case in Corpus Christi, the Section 2 case, we filed to seek that kind of relief, to try to bail Texas back in. And separately, in the big Section 2 redistricting case, they have also filed to try to bail Texas back in under Section 5. So hopefully that will prevail in one, if not both of the cases. But it's hard to predict because there's very, very little out there about how a court is supposed to decide whether to bail in a state or a town or whatever.
So when we're looking at our cities and counties and school districts, what sort of policy changes should raise a red flag or make people concerned that that government unit might be violating the Voting Rights Act?
The biggest and most obvious kind of change that should be a concern is a district, a town, let's say, that has districts and that goes back to at-large voting. That's one of the classic ways of trying to suppress communities of color. So switches to at-large voting, any kind of like funny permutations and combinations of like switching single-member districts to multi-member districts and then having this one other at-large, these like Franken-district type things. I always think those are usually weird because it doesn't need to usually be that complicated unless you're trying to do something that maybe you shouldn't be doing. It's not to say that all of those cases would give rise to a Section 2 claim. There's different standards under Section 5 and Section 2. That's like boring and legally. But like stuff like that. Polling place changes are really fishy. They sound so innocuous. But there's an instance in 2008 of an Alaska township moving just one polling place. But what you wouldn't know if you heard just that sentence is that they were moving the polling place to a location such that everyone in the Native American part of town would have to get there by air or by sea because there weren't roads from the native part of town to this polling place. That was blocked by Section 5. no one would have known except that they had to submit for pre-clearance. Otherwise, the one voting rights lawyer who does really important work in Alaska would have been the only one to hopefully find out about it. So that's another thing. I mean, that's not going to usually get a lot of airtime in a newspaper the way a redistricting might. But if you have contacts with people on the ground or community groups on the ground, and if they knew, if they heard about polling place changes to let you know, that can be super fishy. Annexations, I told you about our client in Shelby County and that annexation that severely diluted his district. So any kind of weird annexations, most annexations won't, but if there's something about the way that some people are being allowed to get annexed and others aren't, that's another big one. It could really be anything, though, which is what makes this so difficult. Section 5 required you to submit like changes big and small, all the way from the whole statewide voter ID law or redistricting down to that one polling place change in Alaska. They're all treated the same under Section 5, so it'll be harder to find those little seemingly innocuous things now.
Could you explain the difference between diluting a district and like stacking a district?
Yes, so diluting a district is basically that's when you have a district that would be majority minority and you redistrict it such that it isn't anymore. That's vote dilution. Vote denial is the comparator to dilution, and that's when you outright deny someone the ability to vote. A claim against the voter ID law would be a denial claim, whereas a redistricting case would be a dilution claim. Packing, cracking, and stacking, is that what you asked about? I'm sorry.
I think I asked about 2 of the 3, but I'm interested in all of them.
So other ways to think of bad redistricting, bad things that one can do when redistricting. You can pack a district. What that means is that you would create a majority-minority district, but it would be like 90% Native American, whereas you could have drawn it such that you would have 2 51% Native American districts, but you wanted to stuff all the people of color into one district so that they could only vote and have influence in one district. The case that made that a valid legal claim actually came out of South Dakota, which is why I used the Native American example. Cracking is when you have a situation where you could create a district and generally, let's say that district is going to be not heavy, let's say like 50 point something or 51% Latino, but you break up the community, you cut a line through it such that you just have 20% Latino in 2 majority white districts. Stacking has not yet been recognized by a court, as far as I know, at least. But that's an example where you redistrict in such a way that it looks like it's majority minority, but you have actually looked at who turns out in that district, and you've done it in such a way that, let's say it's majority 52% African American, but you've done an analysis on that 52%, and you know that of them only 3% are going to show up and vote, and you know that the balance of white voters are all going to show up.
Yeah.
So you kind of like gamed it when you're stacking.
Well, will it be a requirement, under the new ID law to re-register? And
You don't need to re-register because of the ID law.
Yeah.
If you still live in the same place where you registered under, then your registrations should stay intact. So it should not affect your registration status. In terms of every voter, it's my understanding, will need to present ID if you vote in person.
Yeah.
But if voters over 65 are affirmatively presented with that mail-in ballot, And I don't believe that the ID law would change that. But it would only change your experience if you went to vote in person, if you wanted to do that instead of doing the mail-in.
I just have a question. If you happen to be just a person who's interested in this, just a member of the public, how can you help? What could be something that you could do as a member of the public? Who could you let know?
Texas Civil Rights Project or NAACP.
Or
Either one of those.
you can contact us also. We have an email address. It's vote@naacpldf.org. So that's another way. If you have any questions or see something fishy happening and you want to email it to us, have us take a look at it.
Well, thank you, Natasha, for the really
Thank you.
eloquent and succinct and eye-opening status of the law. Really appreciate you coming to Austin.
Thank you for having me.
So this is just the beginning of the People's 4B. So leave your papers behind and we will grow.